Thank you. I've spoken on this before, and I gather there are one or two people here who have heard me speak on it, and I just want to say that they're welcome to nod off, I'd hope, but I prefer the rest of you not to. And I also understand there's some lawyers in the audience, and I would ask them as well, if they wish to contradict me, to do it privately and not in front of the rest of everyone else. You know, in all arbitration and adjudication, one would expect that people who agree to this process would then be happy with it and honor the award or that is made. But it doesn't always happen. There are some people who will go into arbitration hoping to win, but intending to contest your decision if they lose. And that's the reality of the thing. And that is why it's very important to just have in the back of your mind, although one oughtn't to be frightened of it, have in the back of your mind that your award might be challenged. Now, awards can be challenged in the courts, arbitration awards or adjudication awards. They have some similarity, adjudication and arbitration awards, but they also have major differences. But it's where the similarity is that you will find any challenge coming. An arbitration award, if it's going to be enforced, by which I mean one party is resisting it and one has to use a mechanism to enforce it, will be enforced under the Arbitration Act. Because the Arbitration Act provides that an arbitrator's award can be made a judgment of the court and enforced accordingly. An adjudicator's award is a matter of contractual relationship between the parties. But again, if the person resists it, one will need to go to a court in order to enforce it. So on both arbitration awards and adjudication awards, enforcement requires a court's intervention. And that is where the challenge will take place, if there is to be a challenge. The award will be challenged on the basis that it's unlawful for one reason or another, and what you have done will be tested by a court. There are limited grounds on which an arbitrator's award can be contested. There are really three. First, that the arbitrator has misconducted himself in relation to his duty as an arbitrator. Well, that generally requires you to show that he's been dishonest in one form or another, which is very difficult to prove, so that doesn't come up often. Also, that the award has been improperly obtained, someone's bribed you to give the award. Well, that also doesn't come up very often. But the third one is the basis upon which arbitrators' awards are generally attacked, and that is that the arbitrator has committed a gross irregularity in the conduct of the proceedings, or has exceeded his powers. There's no interference with an arbitrator's award on the grounds that it's wrong. You may get the facts wrong, you may get the law wrong, it doesn't matter. The only grounds and the primary ground upon which it will be attacked is that you've committed a gross irregularity. And the same applies to an adjudicator's award. It is said to be binding, but there are often very few express grounds upon which it can be attacked. But nonetheless, there will be one fundamental ground that applies to all decision making on which it will be attacked, and that is that you have failed to apply the rules of natural justice. So whether it's arbitration or adjudication, the rules of natural justice are very important, because that is where the attack will generally come if someone wants to interfere with your award. In other words, because there is no appeal against these awards and they can't be attacked on their merits, it is on the procedural issues that it will be attacked, and that is why it's very important to get the procedure right. And that's where natural justice comes in. Now, all the commentaries on the principles of natural justice will emphasize their flexibility. Time again, one will find reservations to the effect that their application will depend on the circumstances of the case. And Baxter, who wrote the definitive book on administrative law in which the rules of natural justice were developed, says the following. The principles of natural justice are flexible. The range and variety of situations to which they apply is extensive. If the principles are to serve efficiently the purpose for which they exist, it would be counterproductive to attempt to prescribe rigidly the form which the principles should take in all cases. So the principles are easy to express, but the difficulty comes in their application because of the variety of circumstances that you will face in which they call to be applied. One cannot be dogmatic and say that a rule laid down in one case will necessarily apply in another case. It's going to require judgment on your part as to how to apply the rules. But at the same time, although one faces that difficulty, if you're going to be an adjudicator, the principal thing is that you need to be a person who's decisive. People are coming to you for a decision, and that's what they're entitled to. And if you're not a decision maker, don't become an arbitrator or an adjudicator, because you will have sleepless nights as you wrestle with what the award should be. It is not a process for blushing brides. It requires a substantial appreciation of what is considered to be fair, which is natural justice, and it requires boldness in their application. The rules of natural justice were developed in the field of administrative law, and again, Baxter gives the history of them as follows. They are ancient rules. The principles are ancient. 2 English judges have ascribed the observance of audi alteram partem, for example, to God himself. And the principle of a hearing was recognized in ancient Egypt and Greece and in Germanic and African tribal custom, in the scriptures and implicitly in Magna Carta. Both principles lie deeply embedded in Roman law and English law. So these are not novel principles, they're not new ones, they've been around forever. And they involve, essentially, I think everyone will agree that they can be put into 2 categories. The first is impartiality, i.e. the absence of bias. And the second is the right to be heard. You might hear sometimes people speak of other principles, the obligation to act rationally, etc., but I don't think that one should bring that into it. The 2 principles and the 2 procedural principles are impartiality and the right to be heard. Both of those, you'll see, concern the process. They don't concern the merits, they concern the process. They arise as a matter of policy because policy takes it that decisions must be made according to an adequate procedure, but not just as a rule. If there is an adequate procedure, there is a better chance of getting adequate justice. If the procedure is wrong, you will find yourself stifled in achieving the result, the proper result. Now, there was a time at which there was some doubt as to whether the principles of natural justice apply in adjudication, but it can be taken now that it's settled in England that they do apply. And there are cases in England which have held that, and I don't think I need to go into it. It can be settled now. If anyone were to contest that the rules of natural justice apply, I don't think there would be any success in that. There are a few cases that have come before the courts in this country on adjudication. But be wary of one case. It is the case of Sasol Chemical Industries versus Odell, which might be thrown at you at some time. It was a decision in the Free State Provincial Division, which doesn't necessarily mean it's bad. But in this case, it was held that the rules of natural justice do not apply in adjudication. And if that is ever said to you, I would advise you to be skeptical of that and put it aside and get on with the matter as if the rules of natural justice do apply, because that decision, I think, is not going to survive. Now, let me turn first to the first principle, and that is the one of impartiality. Quite obviously, and let me say immediately, before I even get to that, you know, if you have any doubt as to what the law is, you should apply your common sense. Because in my experience, the law generally coincides with common sense. People say that the law is an ass, and I reply, lawyers and sometimes courts are asses, but not the law. The law is sensible in most cases. And if you've got a good sense of right and wrong, and you're not sure what the law is, apply your sense of what is right and wrong, and you'll probably come to the right conclusion. So the law is not something that has to be feared or studied in great detail on this. It is largely common sense. It is encapsulated in that phrase that you will find in some of you attend churches and have different religions. Do unto others as you would have done unto you. That, I think, is the basic principle upon which all law is based. There have been books written in which it is on what is justice. And one book in particular, which says the way you test what is justice is ask yourself, is make a rule without knowing in which position you will be in. Will you be on one side or the other? And if you're willing to accept that rule, whatever the outcome, whichever side you're on, then that is probably justice. Anyway, that was a diversion. Let me turn back to impartiality. There are, again, few cases in which actual bias is relied on. And I don't need to dwell on that for long. Actual bias, by that I mean the predisposition to find for one party or the other. That doesn't happen very often. There may well be biased judges, but it's very difficult to establish that in any event. More important is where there is the appearance of bias. In other words, whether the adjudicator is or is not biased is not relevant. It's how he or she appears to the parties. Justice must be seen to be done, and there must be confidence from both parties in the process by which that occurs. There are two circumstances in which it becomes relevant. And the first is in taking the appointment in the first place. And the second is in the conduct of the adjudication itself. Now, as to taking the appointment, the test was the test has been laid down in a case early on in the Constitutional Court of President of the Republic of South Africa versus the South African Rugby Football Union. Let me just tell you briefly the facts of that case. You may or may not recall that the president, who was at that time Mr. Mandela, set up a commission of inquiry into the affairs of the South African Rugby Board, which was then under the presidency of Mr. Louis Late. Mr. Louis Late went off to court contesting this, the legality of this commission of inquiry. The High Court said it was Mr. Mandela had acted improperly, set aside the appointment of the commission, and it ended up in the Constitutional Court. Well, when it got there, Mr. Late objected to the presence of all the judges. He said that they all gave the impression of bias for a very simple reason. The Chief Justice at the time had acted for Mr. Mandela in his trial. Judge Sachs had been a very prominent member of the ANC, and there were allegations against a lot of the others. And he said, well, how can I get a fair trial in front of people who are obviously biased in favor of Mr. Mandela? Well, you can imagine that if that had been upheld, one would ask, well, who could hear the case? In any event, the judges rejected that, and they laid down, which was not new, but they repeated it, the test for the apprehension of bias. Let me just... The correct approach to this application for the recusal of members of this court is objective, and the onus of establishing it rests upon the applicant. The question is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case. That is, a mind open to persuasion by the evidence and the submissions of counsel. You'll see from that that the test is not what this particular litigant feels. He may say, I think you're biased. Well, that's not a reason not to take the adjudication. The test is whether a reasonable, objective person would make that decision. And if a reasonable, objective person could have no grounds for objection, it doesn't matter what the particular litigant thinks. You'll find that test laid down in all the law in this country and in England and other countries that apply the common law, and I dare say countries that don't apply the common law. Now, there are various circumstances that have been identified as creating an apprehension of bias. The obvious first one is, do you have a financial interest in the outcome? Now, again, it's a matter of some judgment, because one might ask, well, if the employer is Old Mutual and you have a few shares in this massive company quoted on the stock exchange, is that a reason to withdraw? Well, I think it would be commonly said that that is not a reason to withdraw. But at the same time, quite obviously, if you are a member of a private company and your dividends will depend upon the outcome, one ought not to be in the case. It's again a matter of judgment as to where the cutoff point is. As with all matters of this nature, one can't give you a definitive dividing line, and it is, as I said before, a matter of judgment and a matter of common sense. There are other relevant interests that you ought not to have before you go into a case. Perhaps the most prominent case that illustrates that is the case in England, in which, I think there's an English barrister here, so please, I might get the facts wrong. But President Pinochet visited England and they wanted to arrest him. Anyway, it ended up in the courts, and it came eventually before the House of Lords, on which Lord Hoffman was sitting. Lord Hoffman was a former South African who was made good in England. Anyway, he was an unpaid director and chairman of a company that carried on the charitable elements of Amnesty International. And this case had been brought by Amnesty International. It was a party to an appeal. Well, he said that that didn't disqualify him, but that was taken further and it was found that it did disqualify him and he ought not to sit in the case. So again, there are other interests that you might have, apart from financial interests, that would disqualify you from sitting in such a case. There is also the situation in which you've had an association with one or other of the parties. It might have been a business association of some kind. You might have close connections with the parties or with witnesses that you're going to hear. There are relationships which might give the impression of solidarity. For example, in the rugby union case I mentioned. There are cases in which you have active participation in a body or of some kind that has an interest in the matter. Well, all of those are examples of the position in which you might find yourself, in which your ability to hear the case will be challenged. All will be a matter of judgment. I mean, you can have a case in which you're a member of the SPCA. Well, it wouldn't harm anyone if you had a case concerning the SPCA. But these are all a matter of judgment that you might have to apply. More difficult, though, is cases in which you've expressed opinions or held views that are relevant to the case in issue. Now, some of you might have written an article in a journal of some kind in which you've expressed views on a particular topic, and it comes up before you. One party might say, look, you already have a view on the subject. I won't be able to persuade you to a different view. You should not sit in the case. Needless to say, if that was the case, most judges would not be able to sit in cases. because they spend their lives making decisions, saying what the law is, and other cases come before them in which they are told, you said that was the law on the last occasion, this is what precedent requires you to apply that again. This is an area of some difficulty because none of us are completely neutral. None of us do not have views, particularly if you're involved in the industry. You have views on how things ought to be done, what is required to be done, and you're unlikely to move away from those views. That is not a ground in itself, though, on which not to sit in a case. Again, that was a matter dealt with in the rugby union case, and the judges said the following. In the case of a judge of the highest court of the land, other considerations may be taken into account. They quote a case from America with approval in which the following was said. Supreme Court justices are strong-minded people, men. There are now also women. And on the general subject matters which come before them, they do have propensities. The course of the decision cannot be accounted for in any other way. The fact that some aspects of these propensities may have been publicly articulated prior to coming to this court cannot, in my opinion, be regarded as anything more than a random circumstance that should not by itself form a basis for disqualification. None of us are neutral, but you have to have an open mind. And an open mind, though, is not a vacant mind. An open mind is one that will hold views, but will be open to persuasion. That is all. If you have written articles on the subject, your response will be, I may be wrong, I have an open mind, and persuade me that I was wrong. So merely your involvement in issues is not a ground on which to recuse yourself. The second area in which this becomes important is in the adjudication of the case itself. There in particular, one must have an open mind and demonstrate that you have an open mind. There'll be many issues on which there are established practices. One ought not to be in a position where one says to the parties, whether by conduct or in words, don't talk to me about that. That is my view. I've expressed it before, I hold that view, and you won't persuade me otherwise. One must always give the impression, even if you have reservations, that your mind is open to hear another view. So those are the two areas in which impartiality become important. Perhaps the more important one, though, is the right to be heard. Now, arbitrators are in a far better position than adjudicators on this. Arbitrators are in a position in which they most often will sit back and have the case presented to them. They will not have to themselves ask if people are being heard. The parties or their representatives are there, and they are heard. The second thing about arbitration is that you generally have a longer period of time in which to hear people. That is different to an adjudicator in both respects. An adjudicator is not someone who simply sits back and listens to what the parties present. He or she is required to be inquisitorial, to find the truth. It is said in the law, in the courts, that courts are not about truth, but about proof. And that's very true. Courts don't go out to find the truth. They say, prove your case before me. If you don't prove your case, I don't know where the truth lies, and it doesn't matter. You haven't proved your case, and that's the end of it. In adjudication, you're more concerned with truth. You're not asking other people to prove things. You often have to go out and find the facts yourself in order to make your decision. The second thing is that you will be under pressure of time. And you'll say, well, how can I hear everyone if I've got to make a decision in the next week or 3 days or whatever? Well, we'll come to that, but in one way or another, you must allow people to be heard. I've come across, not only is it one of the rules you must apply, but the fact of the matter is it makes for better decision making if you hear people. I'm always astounded at people say you don't have to be heard. Your decision making is better if you have as much information as you have, as you can get, and that includes hearing what people have to say. One used to find in the court so often that administrative officials in government who were challenged on their decision on the basis that they didn't give the party the right to be heard, which I didn't have to. To which my response was always, well, why didn't you? It's good for you. It helps you. You know, that was said in one case where people said, well, you don't have to hear him, and the answer is obvious. And this is what a court said about that. The path of the law is strewn with examples of open and shut cases which, in the event, were completely answered. They're strewn with examples of inexplicable conduct which was fully explained, of fixed and unalterable determinations that, by discussion, suffered a change. One can very seldom say, there is no answer to this. There may be an answer, and one should ask for it. Another case said, the right to know and effectively challenge the opposing case has long been recognized by the common law as a fundamental feature of the judicial process. Now, there are two elements of that as well. First of all, it's the right to know the case against you. What is it that I have to answer? If I don't have that information, I can hardly be heard on the issue. And the second is, once I know the case against me, I have an opportunity to have my say. Now, the right to know the opposing case includes any material placed before the adjudicator by the parties. But it will also extend to communication with the parties, disclosure of your own views and knowledge, and any assistance you've received from third parties. If you've acquired information in your ferreting around, you must put it to the other parties, in particular the party against whom it's going to operate. Tell them what it is. This is what I have before me. I will be taking it into account in my decision. What do you have to say before I do so? Disclose your own views that you might hold on particular things. This is my view on the subject. What do you want to say? If you have sought the assistance of a quantitative surveyor to reach your decision, tell them what the quantity surveyor said so that they can answer to it. Now, how does one go about that? Well, one thinks when the right to be heard of courts in which a long process takes place and people appear and they have lawyers and they want time to do this and present things, etc. And they may well tell you that they need all that in order to exercise their right to be heard. Well, that's not correct. It was dealt with by a very, very sound and practical judge some years ago in another case in which he said the following: it is clear on the authorities that a person who is entitled to the benefit of the audi alteram partem rule need not be afforded all the facilities which are allowed to a litigant in a judicial trial. He need not be given an oral hearing. He need not be allowed representation by an attorney or counsel. He need not be given an opportunity to cross-examine, and he is not entitled to discovery of documents. But, on the other hand, and for this no authority is needed, a mere pretense of giving the person concerned a hearing would clearly not be a compliance with the rule. For in my view, it would suffice if he is given such a right to make representations as in the circumstances do not constitute a fair and adequate opportunity of meeting the case against him. So the extent to which this right is to be accorded will depend, again, on the circumstances of the case. If you have very limited time, it follows that very limited opportunity will be given to be heard. But in one way or another, a party must be given that right, and in particular, the party against whom you're going to find. Now, those are essentially the two rules of natural justice and how they would be applied. And I go back to what I said in the beginning. As you'll see, a lot of that is a matter for judgment. That's why the writers and courts have said it will depend upon the circumstances of the case. That does not mean that the rules themselves depend upon the circumstances of the case. Both those rules are inviolable and they must be complied with. It is in their application that there will be variation in depending upon the circumstances of the case. That I leave to you as a matter of your judgment. And as I say to you, said from the beginning, if you're doubtful about what the law is, it is common sense. Do not be too afraid of the law. If you have a good sense of judgment, if you know what is right and wrong, and particularly if you ask yourself, would I like that to be done to me? If you can't answer that question in the affirmative, then you shouldn't act in that way. In administrative law, it has been said that the rules of natural justice and all procedural issues it will be applicable and will render your decision liable to be set aside, even though it is not material to the outcome of the decision. The courts have said procedures in themselves have a value. Don't tell me, well, if I'd done that, the result would be the same. Procedures in themselves have a value, irrespective of their materiality to the outcome. I don't think that one need to consider that to be the rule in adjudication. There have been cases in which it has been said that we will look at the materiality of the outcome, and that is again because of the nature of adjudication. It has to be done quickly. It is done inquisitorially. It's different to the normal process of making decisions. So the materiality of the outcome is going to be relevant to whether your adjudication award is liable to be set aside. But perhaps the greatest test for the application of these rules is transparency. If you have any doubt, express it. Let people say what they want to say. Transparency, transparency, and transparency will get you through most cases. I think that's about all I have to say. Thank you very much.